Welcome back, Peter Chow again. The last episode we talked about types of leads, different types of leads, and why we want to distinguish them as different type of leads would require the landlord to certain requirement for the landlord to terminate the lease. Um, so in this episode here, we're going to talk about what should go into a lease when you and the landlord or the landlord and you um, want to draft up a lease. There are some basic things that you need to know. Um, at least what I said earlier is a contract. As a contract, there are certain requirements before before it can become legally enforceable. For a lease, at the very minimum, before we start, what I would suggest is that there are all types of form lease out there. Um, I would say use some of them, especially from the ones from the trade association. They're pretty good because it's pretty complex, right? So you drop your own lease, you may forget stuff that are vital, or you didn't know that's important, that you didn't put it in. So when you use a form lease, it usually contains all the major legal requirements already. So all you need to do is just fill in the blanks. And I think that's pretty important, right? So at least you don't miss on the basics. When people think of renting an apartment, they will think about who the landlord is, the property location, how much money to pay, when it's considered late fees, how much are the late fees. That's pretty much it. But in fact, to be legally enforceable, not just enforceable, to be legally adequate, that will truly reflect the party's intention when there's a dispute, it should contain a lot more than a minimum requirement. Um, so, like in California, there are certain things that even you don't put in the lease, that's already implied in the lease. Okay, the most common one would be the good faith. Um, People who are party to the lease has to comply with the lease in good faith. Okay, that's one. And another major implied thing that the lease has in California is called the implied warranty of habitability. This is a set of law that the state of California has decided long time ago that tenants in California to a residential lease, important. Commercial lease is not in here. We're not talking about commercial lease. Residential lease, there's certain right, there's certain enjoyment. A residential party should enjoy things like the heater's got to be working. There got to be screen doors. Those are the things that, long as they're implied in every single lease, they're also not waivable. What I mean is that the landlord can say, well, the heater doesn't work that well, okay? But if you want to take the apartment, I'll give you $50 off per month. Therefore, from now on, I'm not responsible for the maintenance of the heater. He cannot do that. That would be illegal. Okay. So in California, there's a set of law called the implied warranty of habitability. Now, we will go over that because it's pretty complex, so we're going to go over that by itself, one by one in the future, in a future episode. But you just want to be aware of that. Strange thing though, air conditioner is not included in the habitability. So if you're renting an apartment in Palm Springs, and if your air conditioner doesn't work in the summer, if you don't put that in the lease, that the landlord will be responsible for it. Guess what? You are liable for it. Okay. Another item that's implied is called implied warranty of quiet enjoyment. Okay, now this applies to both residential lease and commercial lease. What that means is that the tenant has the right to enjoy the rental unit, full use, right? Not only the landlord cannot disturb it. Anything within the landlord's control, he's also bound by it. So let's say you talk about an apartment complex, how other tenants in the complex behave. If there's one that's committing a lot of nuisance, the landlord might have to step in to stop it. Okay, um, that type of thing. Normally, the outside stuff, out like people from outside the complex, you cannot hold the landlord liable for that. Generally, okay. So outside the implied warranties, habitability and quiet enjoyment and implied good faith, everything else that you want to be included in the lease, you should put it in. If it's not in there, the law is that it's not there. Okay? For example, the air conditioning. If you don't put down in there specifically, the landlord is going to be responsible for it. That means you're responsible for it because it's not in the implied warranty, right? So anything that you think that's important, okay? It might not be important for Joe or John or Smith, but if it's important to you, you got to put it in. If it's not in the lease, you're not covered to it. When there's a dispute, you lose on that issue, okay? So make sure you look at the lease as a whole. You say, does it really reflect everything that I want? It has to include all that. Another caveat to a lease is this: whoever drafted the lease, in case it will be responsible for all the ambiguities. So let's say there's one term in it, it's not really clear, and it turns out the landlord is the one who drafted the lease. Guess what? If there's a dispute with respect to that particular language, the court's going to rule against the landlord. So whoever considered to be the drafter of the lease will be held liable for all the ambiguity that it causes. Okay, that's one thing to keep in mind. Okay, so basically, when you enter with the landlord or anyone into a lease, um, remember the implied warranty of habitability, implied warranty of quiet enjoyment. Those two will go over in detail in the future episode. Implied there's good faith on both sides, and any term that's not in the lease, it's not there. Okay, so you have to put it in there. Okay, subleasing and assignment, those two are really important. Let's say you sign a year lease, right? If you have any doubt that in the middle of the lease you might want to you might get a new job, right? So you want to put something in there to protect you because it's not there. Guess what? Assignment and sublease, the difference of which we'll go over again in the future episode. That you want to bring someone else in, take it over. You got to put that in there. Okay, so those are the issues that you need to consider. So again, the information contained in this video here is only meant for educational and informational purposes only. If you have an actual problem or situation that you need legal advice, I mean, you should also, as always, go see an attorney. Get some good advice before you make up your mind. Finally, subscribe to our channel. Give us a like if you like this content. Your support is really important to us. And if you have any comment about our shows, anything you would like to wish to learn a little bit more, let me know. Okay? And I'll see you next episode.